So the issue of New York's new concealed carry bans and their defiance of Bruen is once again in front of the Supreme Court. So let's break down what has happened. Now, before we jump into this video, I want to thank one of the new sponsors of this channel, which is Home Title Lock. This company can actually save you a lot of time, money, and honestly, a very huge legal headache. Many of you probably protect your car, your home, and maybe even your phone with insurance, but what about your home title? What about your home? Did you know that there is a new and growing wave of criminals that are actually targeting your home titles and going after your home? I'm now partnering with Home Title Lock, not just as a sponsor, but also I have their product to protect my own home title. And really the best part is, if something like that ever happens to me or maybe to you, the team over at Home Title Lock will handle the entire legal process and will help to restore your home title. If you're interested, you can click the link down below in the details section and also in the pinned comment. And right now they're offering you a free 30-day trial and a comprehensive home title scan so you can make sure that your property is actually safe. All you have to do is go to hometitlelock.com/armscholar. And if you use the promo code ARMSCHOLAR, you will get that free 30-day trial to protect your title. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans in states like New York are once again going back in front of the Supreme Court. You may recall that the Supreme Court recently granted, vacated, and remanded the Antonio case, which is the case we're going to be discussing. They sent that case back down to the Second Circuit for a new decision in light of the Supreme Court's 8-1 decision in the Rahimi case. The Antonio case challenges the state of New York's new hyper-restrictive concealed carry law, which is the CCIA, and that was passed just 8 days after the Supreme Court issued their Bruen decision. The Second Circuit issued their new decision in light of Rahimi, and essentially they just reissued the same decision, finding that Rahimi did not actually impact the outcome of the case at all, and so they essentially issued the same decision. In response to that, the plaintiffs have now decided once again to go to the Supreme Court to seek Supreme Court review in the hopes that New York's new concealed carry bans and the defiance of the Bruen decision can be struck down and stopped once and for all. Now, this issue of concealed carry bans in New York has been a long battle, but really should have ended after Bruen. In Bruen, the Supreme Court struck down New York's original May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. However, despite that, New York rushed through the Concealed Carry Improvement Act, the CCIA, just 8 days after the Bruen ruling. This new law was done in direct defiance to what the Supreme Court said in Bruen. This law was challenged in multiple cases, and in those lawsuits, preliminary injunctions were granted, halting some aspects of the CCIA. However, the state of New York then appealed those decisions up to the Second Circuit, who then granted blanket stays on all of these rulings. Now, in response to that, GOA, for the first time, decided to go to the Supreme Court on an emergency basis, seeking emergency review from the Supreme Court. The Supreme Court, on review of those emergency applications, denied relief, but the order of the court did say that the Second Circuit could not simply drag their feet and issue blanket stays. They would need to expedite hearing in these cases, and that's exactly what happened. Recently, the Second Circuit ruled in 5 CCIA cases, and the big argument really came in the Antonio case, which is argued and led by GOA. The Antonio case is a challenge to the CCIA at large, including the process to get the permit and then also the just catch-all sensitive location bans. The Second Circuit ultimately vacated some of the district court's injunction against the enforcement of the CCIA. Now, in their decision, the Second Circuit distinguished Bruen as an exceptional case. Therefore, the Second Circuit vacated a lot of the district court's injunction and ruled in favor of the state of New York. Now, in response to that Second Circuit ruling, GOA then filed a second petition for emergency Supreme Court intervention. Although this case was still in an interlocutory posture, the Supreme Court did actually grant a GVR, which is a grant, vacate, and remand of this Antonio case back down to the Second Circuit for a new decision in light of what they said in Rahimi. Now, Rahimi was an 8-1 decision, and the majority of the court found that the domestic violence restraining order federal laws did not violate the Second Amendment because there were traditions and principles that pointed to the constitutionality of that law. Now, originally when this case was remanded, the Second Circuit was intending to have a ton of consolidated CCIA cases reopened and then re-argued and decided. However, then they decided to only move forward with the Antonio case because in their opinion, that was the only case that was GVR'd in light of Rahimi. So that's the only case they decided to rehear and redecide. And after they heard oral arguments and new briefs on this issue, they decided to rule, and once again, they upheld their prior decision. They essentially ruled the same way and found that the Rahimi ruling did not change the outcome of their case at all. In the decision, the Second Circuit stated that in the wake of Rahimi, the Supreme Court granted cert in Antonyuk, summarily vacated our judgment in that case, and remanded the case to this court for further consideration in light of Rahimi. Having reconsidered the prior decision in light of Rahimi and the parties' supplemental briefing regarding the effect of that decision on our reasoning in this case, we now issue a revised opinion in Antonyuk. We reach the same conclusion that we reached in our prior consolidated opinion. So in reality, nothing really changed with the Second Circuit's new 246-page opinion. It was, of course, remanded to them in light of Rahimi for a new decision, but ultimately they found that it came out the same way. Now, there was something else in this opinion which was different and actually very important. And what ended up happening is the Second Circuit disagreed with the Ninth Circuit's recent decision on a similar issue of concealed carry bans. They disagreed with the Ninth Circuit's ruling in the Wolford case, which deals with Hawaii's concealed carry decision. You might remember that in the Wolford case, the Ninth Circuit found that the public carry ban in Hawaii was permissible because the state of Hawaii in their statute had various reasons and ways that you could actually receive notice that carry in the private property was allowed. The state said that there could be a sign posted. The business owner could actually verbally tell everyone that carry was okay at that location. But here in the Antonyuk case, the Second Circuit disagreed with that analysis performed by the Ninth Circuit, and the Second Circuit found that an outright carry ban is a violation of the Second Amendment. Now, that was very important, and it's a good thing because you have a circuit split at least on a little issue, a very important issue, but a critical aspect of the CCIA and then other carry bans that are in place in other states, which are being passed in direct response to Bruin and essentially trying to have these blanket carry bans on private property. Now, as a result of this new Second Circuit decision, this Antonyuk case is heading back to the Supreme Court. On January 22nd, the plaintiffs filed for Supreme Court review. They filed the writ of cert, and they notified the lower court that they will be seeking a reversal of what the Second Circuit said, and they're taking this back to the Supreme Court. In this notice to the lower court, they state that, "Dear Judge Sotheby, pursuant to this court's order on December 2nd, 2024, the parties hereby provide this joint letter. On January 22nd, 2025, the plaintiffs filed their petition for a writ of cert with the United States Supreme Court. The parties propose to file another joint letter within 14 days after the Supreme Court either grants or denies plaintiff's petition. If the court requires any additional information, we are happy to provide it." So this new petition in the Antonyuk case sets up a critical review of a state's hyper-restrictive concealed carry bans and laws that were passed in direct defiance to what the Supreme Court said in Bruin. This Antonyuk case is one which the Supreme Court is very familiar with. It's a case that they recently granted, vacated, and remanded for re-review in light of Rahimi. They wanted maybe the Second Circuit to modify their decision, maybe correct some errors in light of Rahimi. They gave them an opportunity. Maybe it was just the Supreme Court punting at that time because they didn't want to get involved in this issue. But ultimately, the Second Circuit just issued the same decision and found that Rahimi did not change the outcome of the case at all. And as a result of that, this case is now back in front of the Supreme Court. So now a concealed carry ban case is back in the hands of the Supreme Court. It's a case that deals with a law passed in direct response in defiance of Bruin. New York was the first one to pass this type of concealed carry ban, and then you had other states like California and Hawaii do similar things. And currently there's a ton of litigation in those cases as well, which are moving their way through the process at the Ninth Circuit level. And this case here could correct a lot of that. And so this is back in the hands of the Supreme Court, and we will see what they want to do with this. But again, they GVR'd this prior. They're familiar with this case. They've kind of been involved in this Antonyuk case because, again, it deals directly with the prior laws that they struck down in Bruin and then defiance of Bruin with this new law. So again, it's a case that the Supreme Court is familiar with and they've been involved with prior. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.